Hello, this is Dr. Schemberger, and in this video lecture, we're going to focus on how we track criminal cases. This is where I will walk you through really how it starts, and we will take you all the way up to the jury selection process, and then we'll stop there. So this is a long and often complicated process. It also, in many ways, is the argument as to whether defendants really have a right to a speedy trial as guaranteed in the Constitution, because many criminal cases will, even for I won't say a simple charge, but even a lower level felony sometimes can take months before it is resolved in some way. For felonies that are greater in nature, many times trials aren't even considered on the docket for maybe another 1.5 to 2 years. So sometimes it goes really slowly. Each step throughout this process can produce a number of motions and records that, when they are placed in the case file and you're able to review that you might need to take note of. And sometimes that can be your story. The story is not so much the trial when it happens, it's what has been filed in that case file. That's really sometimes the story. Now, what you might need to understand is that some records could be closed if the judge determines that a defendant's right to an impartial jury could outweigh the public's right to know. And that has been a standard test that has stood for decades. So when records are closed, it doesn't hurt to ask the judge if you could just find out what the basically some kind of idea as to what those records are. And just know that really they are trying to protect the process. So and when they do that, just sometimes you might have to trust the process too. So, but just know if some records are closed and or they're sealed and you're not able to access them, it doesn't hurt to ask what could be in there. But just know that that could happen. So just as we examined the anatomy of a civil case, we're going to do the same thing for a criminal case. It all starts with the arrest. So you might remember some of this when we examined the breaking news portion, in which we examined the cop beat. Some reporters, when they do the cop beat, it kind of carries over for them in the court beat or the legal affairs reporting beat. So it starts with the arrest, in which the suspect could be interviewed, as well as jails that keep log books that can be a rich source of information for you, so you can see who the inmates are as well as who has visited the inmates. It could produce some insights as you write your story, and it might not. After a person is charged, then the police may set the bail initially, but then the judge can determine the bail for the rest of the proceedings. So a judge can, upon recommendation of an attorney, maybe an attorney is pressing that a bail amount be lowered, a judge will consider it. It depends on the charge, as well as the history of the suspect. There are a lot of factors that go into play in determining what the amount of the bail or the bond is. So let's talk about bail, because many people tend to use bail and bond interchangeably, and I can understand why, but there are some differences. The bail is the money itself that ensures that the defendants in criminal cases will appear for their proceedings and their hearings. And in any time that they miss a proceeding and they should have been there, then the judge can issue a bench warrant for that suspect's or that defendant's arrest. So the bail amount is set for a reason. It is a system that allows defendants to get out of jail while awaiting trial by posting bail. You know, some defendants get put in jail for charges that, yes, they're serious charges, but they're not too serious to where they're going to cause any harm to the public. So some of these defendants, they need to get back to work maybe. You know, sometimes people will just run afoul of the law. A DUI charge, for instance, even though it's sometimes more of a misdemeanor, but maybe an assault charge, maybe they just happen to be in the wrong place at the wrong time. That can happen. But we've got to let the proceedings take care of that. So until the case is finalized, then sometimes defendants need to get back to life a little bit. So again, the bail is going to be set, yes, at a reasonable amount, but the amount is going to reflect all the factors that the judge has considered. The bond, some people tend to use that interchangeably. Bond is more of an insurance, and those are issued by a bail bondsman. Now in Kentucky, we don't have bonding companies. Those are not allowed in Kentucky. Tennessee does. So if you've ever traveled into Clarksville, then you might have seen all of the billboards for all the many bond companies that exist, especially around the downtown area of Clarksville. With the bond system, the defendant or even that defendant's family will pay a portion, typically 10% of what the amount is, and then they put up, the bond company will then basically issue the money to the defendant or the defendant's family in exchange for some kind of collateral. That collateral could be a car, it could be it could be a number of things. So you got to make sure, even for a family member, are they going to be able to trust that their loved one who is now a defendant in a criminal case, are they going to appear at their hearings? Now, if the defendant chooses not to raise the money in any way, whether through a bondsman or just having it gifted in some way by the family, then the defendant remains in jail until the trial dates, or really they remain in jail, but they do appear in court throughout all of their hearings. A defense attorney can ask to have the amount lowered. In many cases, that is granted by a judge, and in many cases, it's not. Again, it depends on factors. A suspect also can be what we call ROR'd, which is released on recognizance. Basically, it's the defendant realizes the seriousness of this issue. This defendant probably has not had a criminal past at all. Again, just some unfortunate circumstances, and sometimes a judge will go ahead and ROR someone. The prosecutor likewise can oppose or even ask for a higher amount than even what the judge sets. So, just because the defense attorney requested and the judge reviews it doesn't mean that the prosecutor is absent from all of this process. He or she can argue no, either against the defendant's attorney's request, or even try to argue, or argue is really not the right word, but just have the judge reconsider a certain bail amount. So a defendant's in jail, and we've got the first court appearance, and that starts with the arraignment in district court. So you might have remembered that also from the breaking news portion. This is where the defendant is going to enter a plea to a formal charge, whatever that charge is. So again, all criminal charges start in district court. Your misdemeanors as well as your felonies, they all start in district court. So this is where a defendant is going to enter a plea of guilty or not guilty, okay? Guilty or not guilty. It's never guilty or innocent. Everyone's innocent, so we're not determining somebody's innocence. What we're determining is whether someone is guilty, or what the courts are determining, I should say. We don't determine anything as journalists, but what the courts are trying to determine is whether a defendant is guilty or not guilty of a charge. But it all starts with the arraignment process. Sometimes at the arraignment, the judge might set a bond as well. That's probably where the judge might have reconsidered the initial bail amount that was set, and this is where they might ROR somebody or lower the amount. After the arraignment, usually within a week or so, then we have the preliminary hearing. And at the preliminary hearing, this is where we get to kind of see some things unfold a little bit. This is where initial evidence will be presented. Prosecutors may not want to do this. Sometimes they do, sometimes they don't. I have to admit, in my years of covering the legal affairs beat, I've not seen, I could probably count on one hand and really probably with two fingers, the number of times I have seen prosecutors share any kind of evidence at a preliminary hearing. Much of the time, the preliminary hearing includes some testimony, some brief testimonies and questionings, but that's about it. It's at the preliminary hearing that the judge is going to determine whether there is enough sufficient evidence to exist to bound the case to the grand jury? In other words, is there enough to determine probable cause? So that's what the judge is trying to, or what the purpose of the judge is at this point in the criminal case process. So at the preliminary hearing, it's pretty important. If a defendant is, if that case is bound to the grand jury, then that's the next level it hits. So what is the grand jury? It is a panel of peers. They are chosen through, just like you are selected for a jury to serve on a trial or for a 2-month period. The grand jury runs similarly. So they only hear from the prosecutor. The proceedings are held behind closed doors. So we never, the media, nobody, not even nobody in the public. This is the one process in the court proceedings where hearings, anything's not open to the public. Now, what we do as journalists, we always will know where the grand jury meets. They are going to pretty much meet at the courtroom facility, wherever that might be for your area. But we can sit outside the grand jury rooms. We can look at all the subpoenas. The subpoenas are placed in files. So if you are following either a high-profile case or you are following a murder case, and you can look in the files to see who might have been subpoenaed to testify in front of the grand jury. Some states do require prosecutors to seek grand jury indictments, and it's optional in others. Kentucky is one of those where, if a prosecutor feels that there's enough evidence against a particular defendant, then they are going to go ahead and proceed with a grand jury indictment. But prosecutors in Kentucky do have that option. If there is sufficient evidence, then the grand jury will issue what is called a true bill. That's an indictment. If no indictment is issued against a defendant, then it's called a no true bill, meaning that the evidence is not true enough to warrant any further proceedings against the defendant. Sometimes grand juries also will issue what is known as presentments. Basically, they're just reports. These reports are really neat, and a lot of times these reports will come at the end of a grand jury's time of service. In Kentucky, most grand juries serve for about 2 months. So at the end of the 2-month period, then they might issue a report. Let's say a grand jury has been for 2 months been hearing lots of cases that involve all this drug activity. Then they might issue a statement that indicates, what, our officials need to do a better job of strengthening programs that we have in place to help those with some drug problems, but for some reason they seem ineffective. They can make all kinds of opinionated statements, but again, their opinions are based on what they saw in their 2 months of activity. Now, for us as journalists, those are great tips for us. We can take those reports, and you may not do anything with them at that point, but if you collect enough of them over time, you've got a trend story, and it can be really effective to pursue. So don't discount those presentments. When you see one, know that it could be rich with some good information and insights for a news story. So let's determine that, or let's proceed as if a defendant has been issued a true bill. That person has been indicted. Then the case now goes to circuit court. So the grand jury serves as the middle point between district court and circuit court in criminal cases. So now that the case is in circuit court, then various motions likely will take place from here on out. You're going to have what we call PT hearings. PT is pretrial. So pretrial hearings. Sometimes prosecutors, they're trying to make arrangements, or at least the defense attorneys are, but prosecutors are trying to work with them to see what kind of offers could be made, negotiations. So this is plea bargaining that's occurring. Cases often are delayed for trial. A trial date can be set, but about 90% of the time, that trial will not occur on the date that it's set. And that brings to that famous quotation, justice delayed is justice denied. And in the majority of cases, it really is. It's really, sometimes it seems like the system it's designed well, but it still is ill-effective. So there are still problems in the court system. It's not perfect. And I've had several judges tell me in my years as a court reporter that, it's not a perfect system, but it's the best we have. I can't argue that. That is true. Defendants do have a right to a speedy trial. It's the constitutional amendment. So, that's not really a story idea per se, but sometimes you've got to keep that in the back of your mind when when you've been following a case, say for 2 or 3 years, and then finally it comes to trial. That's something to keep in mind and try to figure out why all the hangups throughout it. It's all because of these pretrial hearings. Something comes up, and it's just maybe rescheduled. Sometimes there can be some detours in the case. It just depends. Every case is different. Some of the trial decisions that are being made early on in the process. So we might have a trial date, and that is a goal to work toward that the attorneys do. But in that process, they're trying to determine, do we want to do a bench trial or a jury trial? So just like what we saw in the civil case, even criminal, it can work that way. The accused has a lot of say in this. So they do have a right to a jury trial. That's also a constitutional right. So just have 6 or 12 jurors. It depends on the state. It also depends on a number of other things. But in Kentucky, we have pretty much 12 jurors. I've always thought a great story to pursue in this is determining, if conviction rates are higher in a jury trial as opposed to maybe a bench trial. That was always a project I never got to pursue, but I always thought that would be interesting. Not many criminal cases go to a bench trial. Some do elect to be tried in a process by their peers, but it's still kind of neat to examine. Let's look briefly at the jury. So a juror is selected for a court case trial through a process known as voir dire. It's a selection process in which the judge, and almost always the attorneys as well, they're going to ask questions of the potential jurors. So jurors initially are randomly selected, and then it kind of goes from there. In fact, anybody who's reporting for jury duty, and let's say they're trying to seat a jury for a trial that's going to occur, say, 3 days from now, then they'll start asking questions of all jurors in the courtroom. Have you ever had a DUI? And if you have, you're going to raise your hand. Well, they're going to take note of who you are. And the reason why is because they've got to make sure they're selecting people who are going to be the least biased as possible going into this process. These voir dires are open proceedings, so you need to be there because they're really important. So if you're covering a certain case, a murder case, it's going to start with this. So you definitely want to be there to see who's going to be on the jury, because you want to observe who is on the jury. More men than women? Is it balanced? What about racial makeup? So you want to note all of these things. You can also get copies of the questionnaires that were filled out by the prospective jurors, because when somebody is called to jury duty, they usually fill out a questionnaire that includes a number of things. And as you probably know, jury pools are determined from the list of registered voters. So that's why it's also important to be registered to vote, because you might be called to serve in this important civic capacity. Juries, this is where also attorneys are trying to determine how they've got to have a cause or what we call a peremptory challenge. In other words, we're trying to find a reason to exclude a juror, because like I said, we don't want jurors who are going to be so biased that it's going to taint the process. So if there's a cause issued, if attorney raises a cause, then the judge can grant permission to a challenging attorney to exclude a potential juror because of that bias. In a peremptory challenge, lawyers on both sides can exclude jurors just for any reason. Maybe it's just, it could be anything. Even if it's not so much related to the case, maybe it's something as simple as a juror cannot be part of the process all week because he's got a conference to go out of town for. It's even something that simple. Well, in that case, then lawyers can decide, yeah, let's go ahead and excuse them. So they'll recommend that to the judge. Now, the makeup of the jury, it's beyond control, but still, it's something you need to observe and include in news stories. A jury is going to be instructed not to speak to you at all during the trial. They're also going to be instructed not to listen to any coverage, not to read anything, stay off their phones. It will happen. Now, jurors can speak after a trial, but judges often don't want journalists even near the jury. So I'm jumping really way ahead on this, but let's say at the conclusion of the trial, when everything is done, the judge will excuse the jury first. That way they've got time to get to their vehicles. That's why you need to try to run out and try to see if you can catch a few of them to talk to them. Jurors' names and contact details typically are withheld from the media, and that's okay, but you can still ask for that person's name. But many of them will not talk, or if they do talk, they're going to talk on the condition of anonymity. So, you've got to, but still, it's your job as a journalist to see if you can speak with any of those jurors at the conclusion of the trial. So the next video, we're going to actually go through the trial process as though it's underway. So that will be the next phase of this exciting beat of legal affairs reporting. Thank you for your attention.